put on the slide there some information about our future webinars in our People Matter series. So immigration webinar coming up on the 12th of October. We've got a legal update on the 31st of October. For those of you in the education sector, we're going to have a People Matter webinar in October. And then the next kind of topic in our People Matter series is going to be on disciplinary and grievances. And you'll see the dates there for those webinars coming up in November and January and March next year. So it'd be great if you could join us for those. Just a bit of housekeeping to begin with. First of all, the webinar is being recorded, and the copy is going to be available afterwards on our People Matter internet page. You'll get a link to that internet page along with a copy of the slides after this morning's session. If you've got any questions, put them into the Q&A, and we've already had the first question that's dropped into the Q&A. So yeah, do put your questions into the Q&A, and we'll deal with as many of those as possible at the end of the presentation. Please note that when you're submitting the questions, your name's not going to be visible to the other delegates, so don't be shy, and Sarah and I will deal with the questions when we can. Also, if when submitting your question, you put your name in, we may be able to give you a more detailed response after the session. And then also at the end of the webinar, you're going to get an opportunity to give feedback. So we'd be really grateful if you could do that, because that helps us plan our future sessions and also make sure that we're delivering what you want. So without further ado, let's move on to today's session on collective redundancies. So what we're looking at this morning are the particular obligations on an employer when they propose to make collective redundancies of 20 or more employees within a period of 90 days or less. So those obligations have been in force in one form or another since 1975, and the relevant legislation that we're talking about for these purposes is the 1992 Trade Union and Labour Relations Consolidation Act, and that implemented the relevant European directive, and so in particular section 188 of the 1992 Act. So what are we going to cover this morning? We're going to cover when are the collective consultation obligations triggered, what are those obligations, and what are the key things to get right, or really the key things to avoid getting wrong. Starting then with the question of when are the particular obligations in respect of collective redundancies imposed on employers? And so the answer, as set out on the slide there, is when the employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. So there's some particular points that I want to draw out here. So first, what do we mean by proposing to dismiss by reason of redundancy? Well, that term proposing to dismiss, that's received quite a lot of attention in the case law. And the upshot of that is that proposing means that consultation must begin while the proposals are still at a formative stage and before a kind of hard decision to dismiss for redundancy has been made. But the employer's decision-making process, it has to be sufficiently well advanced to have identified the fact that over 20 employees might be dismissed within a period of 90 days or less. And next, then, this concept of establishment. So as the slide says, the duty to collectively consult applies only where 20 or more dismissals are proposed at one establishment. So following the high-profile case which looked at the closure of the Woolworths stores up and down the country, it's relatively clear that the kind of entity or unit to which the workers who are made redundant are assigned to carry out their duties, that's what constitutes the relevant establishment for these purposes. And it's also clear, or relatively clear, that it's not essential that that unit or entity has its own management which can kind of independently affect and make decisions about collective redundancies. Just put that in a kind of practical context. What that meant in the Woolworths case was that each branch of Woolworths was a separate establishment. So each shop was a separate establishment, and the collective redundancy obligations weren't engaged in respect of stores that had fewer than 20 employees. And then finally, I just want to draw out, what do we mean by dismissed by reason of redundancy in this context? And the kind of important point to take away here is what's regarded as a dismissal for collective redundancy purposes is much wider than redundancy for the purposes, say, of a statutory redundancy payment or unfair dismissal under the Employment Rights Act. So for collective redundancy purposes, by reason of redundancy, really means that the reason for the dismissal doesn't relate to the particular individual employee concerned. So what that means is that the collective redundancy obligations, they might apply in circumstances which might not be immediately obvious at first kind of blush. So for example, if an employer is changing a large group of employees' terms and conditions through termination and re-engagement, in those cases, the reason for dismissal isn't connected with the individual employees because there's going to be a change to terms and conditions. And so the collective redundancy obligations are going to be engaged depending on the numbers involved. And so the duty also extends to cases where an employee volunteers, or we've got volunteers for redundancy, obviously, of course, subject to the numbers. And then one final point just on dismissals. Dismissals that occur on the expiry of a fixed term contract on the agreed termination date within that fixed term contract, they're excluded from the definition of redundancy for collective redundancy purposes, even if they occur within the 90-day period. So that's when. Sarah.
Thank you, Stuart. So I'm going to deal with what. So what is the collective consultation? Well, it's consultation with the union or representatives, and we'll come on to talk about those in a bit. And it's consultation that has to start in good time. And then the legislation provides those minimum requirements that are set out on the slide. So 45 days before the first of dismissal takes effect, where you've got 100 or more employees, and 30 days otherwise. They are minimums, so it's quite possible, depending on the nature of your proposals, that you may need to factor in a longer period of time to be able to discharge the obligations. That said, from a practical perspective so far, there hasn't been any case law where somebody who's met the minimum obligations has still been found to be in breach, but it is a possibility. What are we talking about? Well, the legislation that Stuart mentioned is very specific about the topics that, at least on which the employer has to start the consultation with by providing information. And these are set out in section 188 of TULCRA. And it's worth noting that until you've provided this information, the clock doesn't start on the consultation. So we've seen a few instances whereby the employer has started discussions and thinks that the clock's running, but they haven't provided the statutory information, and therefore they're not as far on as they thought they were. So what does that information cover? Well, it's the reasons for the proposed dismissals, the numbers and classes of employees who are affected, and then the total numbers of those employees in those groups. So, if you're proposing to dismiss 3 line packers, you'd also have to explain that you've got 20 or more in that entire group, so that the reps can get an idea of the scale of the proposal. The proposed method of selection is something that you need to set out, and obviously that might not be the same for every group of employees, so there might be quite a lot of detail there that you need to give. How are you going to carry out the dismissals? and over what period of time. What you're proposing to do about redundancy pay, if it's different to statutory. So obviously we're talking about potential enhancements. What does that look like? And also information about the use of agency workers. And all of that information essentially is designed to be able to give the reps a good basis on which they can get a grasp of what your proposals are, so that they can then commence getting feedback from their colleagues, members, to be able to engage in the consultation. If you don't comply with these regs, there is a protective award that a tribunal has the discretion to award. It's not mandatory. It is possible for a tribunal to find an employer has been in breach, but not make an award. The awards can be quite chunky though. 1 week's gross pay, so no cap on the pay, 1 week's gross pay for up to 90 days per employee. And it's not designed to compensate the employees, it is designed to penalise the employer. So obviously the more flagrant the breach, the more likely you're going to get an award made against you, and or a hefty one near the maximum. There are some special circumstances which provide an employer with a defence where it's not been reasonably practicable to comply. It's not really that often used, not least because it's quite hard to convince the tribunal to apply it. And even where you're arguing that, you still have to show that in the circumstances you went as far as you potentially could to comply. So an example of where this might be available to you is, for instance, where there's a complete disaster and you go very quickly into an insolvency situation. Even there, you might try and get staff together as a group to try and do something to consult. But it's possible it may apply there, but contrary to that, look at a situation where a business is slowly run down and runs into insolvency. Insolvency won't automatically give you the protection of the special circumstances defence. So moving on, we're going to carve up between us some key topics. Here, it is a massively complex area of law that employers do quite often struggle with some of the detail, and in the time available, we're not going to touch on absolutely everything, but you can see there we've got a number of topics that we're just going to take it in turn to take you through.
Thanks, Sarah. So I'm starting with the numbers game, which isn't great because I'm not great at maths, but there we are. So I'm starting with the numbers game. So what you'll appreciate from what we've said, managing and dealing with collective redundancies is something of a numbers game. You've got this proposal to make 20 or more employees redundant within a 90-day period at one establishment. There's a few numbers to contend with there. So let's kind of delve a little bit deeper into the numbers. So first of all, how should we calculate the number of dismissals which are planned? So in many cases in practice, an employer is going to be looking forward from the start of the collective consultation at the next 90-day period, and looking at the number of dismissals which will occur in that 90-day period. So start from today, look for 90 days, how many dismissals are going to take place in that period. And that's, of course, rather nice and straightforward. But unfortunately, it may not be as simple as that. There's a European Court of Justice case from 2020 known as Markleen. And in that case, the European Court of Justice said that for the purposes of assessing whether the threshold for collective redundancy consultation is met, that 90-day reference period has to be calculated taking into account any period of 90 consecutive days during which an individual dismissal took place, and in which the greatest number of dismissals carried out by the employer occurred for one or more reasons not relating to the individual employees. So what that means, and the kind of takeaway point from that, is that judgment requires employers to look both backwards and forwards from the date of an individual dismissal to determine whether there are 20 or more proposed dismissals in the 90-day reference period, which would trigger the obligation to collectively consult. And that European Court of Justice judgment that was at odds with some previous UK Employment Tribunal decisions that they'd held that the law doesn't retrospectively impose the obligation to consult in respect of dismissals that had already happened, because the tribunal in that case said that would be to require the impossible. And it's also at odds with the express wording of the UK legislation itself in section 188(3) of the 1992 Act, which says that in calculating the number of employees to be considered, no account should be taken of employees in respect of whose proposed dismissals collective consultation has already begun. And so what that means is it's particularly problematic when you're dealing with so-called staggered redundancies. And so whereas it is often the case, employees are being made redundant in tranches. So just to illustrate that point, so suppose that you've got an employer that's proposed 30 redundancies and it begins collective consultation about those redundancies, but the employer then subsequently proposes to make another tranche of 10 redundancies within the same overall period of 90 days. If you applied section 188(3) of the UK 1992 Act, because the consultation had already commenced on the original 30 redundancies, the subsequent 10 redundancies could be viewed in isolation and there wouldn't be any obligation to consult about them. But if you apply the kind of ECJ's decision in that Markling case, the original redundancies would be included when considering the collective consultation obligations regarding the subsequent 10. So what that means in practice is that really careful planning is required on the part of employers. You've got to have a clear understanding of both the past and the anticipated redundancies to avoid kind of inadvertently crossing the threshold number of redundancies within the rolling 90-day period. And what it also means in practice is that employers need to assess their attitude to risk in respect to this issue and the issue of whether the numbers threshold has been crossed. Some employers might be prepared to take quite a bullish approach, given the kind of uncertainty in this area around the UK law and the Markling case, and say, well, those redundancies that I've already dealt with, I'm not going to factor into account in respect of future redundancies, and I'm relatively bullish about that. Other employers are going to, potentially going to err on the side of caution, and obviously the very safest approach, if you're erring on the side of caution, if you're proposing redundancies, would be to look at any other redundancies that have occurred or could occur in any consecutive period of 90 days within which the proposed dismissals are going to take place, even if some of those are prior to the date on which the redundancies have been proposed. And what that might mean in practice is combining what would strictly be separate batches of redundancy into one in order to avoid any kind of dispute about whether the collective redundancy obligations have been complied with. But in any event, it's obviously going to be sensible for employers to put in place a kind of redundancy tracker to keep a record of redundancy dismissals, so it will assist you in determining when the threshold might be met and in kind of carrying out that risk assessment that I've just talked about.
Thanks, Stuart. Just having a coughing fit there, so that was good. I wasn't on that slide. So just picking up on employee reps then. So the first question is always, have you got a recognised trade union that represents the collective bargaining unit that's affected by this proposal? If that's the case, you have no choice. You are obliged to deal with the union in relation to the consultation. And it's irrelevant whether or not the employees affected are members or not of that union. It's the point about whether or not they fall within the bargaining unit that's key. If that's not the case, then you look at whether or not there's a standing employee body with the relevant authority, and then you move on to, if that's not the case, electing representatives. Now, electing representatives, we often get asked, how many do I need to have? Essentially, there is no minimum or maximum number really here. It's looking at the nature of your business, the nature of how the business is structured. Are there shifts patterns? Are there very different groups of staff who are potentially affected. Because what you want is that all the affected employees are adequately represented. And obviously some complex redundancy proposals, you quite often see that there are different proposals for different groups of staff, and that the groups of staff may have different interests in terms of how they might want to respond to that. So there's no minimum number, but what you don't also want to have is a group, a team of thousands in the room. It's got to be a manageable group that you can have useful consultation with. So no absolute sort of specifics on that, but it's having regard to how many are affected, what are your proposals, how are you structured, how is it best to ensure that those affected employees can be represented at the consultation. Then the regulations have some rules around how you run the elections. Only affected employees can be elected. Voting and the results are to be counted in secret as far as reasonably practicable. So you just got to have a sensible method, if you like, of electing the representatives. What happens if you don't get any? Well, it is the employer's duty to arrange the elections, and you are under an obligation to try and get a representative committee. So you do have to have a thought to how perhaps you might persuade some people to stand if you have to do that. It's not an easy, oh, nobody's volunteered, so let's just leave it. However, there is a possibility if you get to the point and you can't get reps, that the obligation to collectively consult may fall away, and you're just left with the obligation to inform the staff of the Section 188 information individually. I think what we would always say, though, when we're advising is that if you get to that point, you'd essentially try and go through all the issues that you would have been obliged to do with staff reps with all the staff. Now, clearly, in a much smaller group of employees being affected, that might be quite easy. If you're talking about huge numbers, then it's hard to see why you can't get the reps. So yeah, don't think there's an easy way out there, because there isn't at all. Thanks, Stuart. You're dealing with the next bit.
I knew I'd do that. I've muted myself. So yeah, looking now at the timing issue of when consultation should start. So the legislation makes clear that the overriding requirement is that consultation begin in good time. But the legislation then also goes on to set out some specific minimum periods of time that have to elapse between the start of the consultation and the date of the first dismissal, depending on the numbers of dismissals that are proposed. So where you've got 100 or more redundancies being proposed at one establishment within a 90-day period, there has to be at least 45 days between the start of the consultation and before the first of the dismissals takes place. And where there are 20 or more redundancies, but less than 100, at least 30 days has to elapse between the start of the consultation and before the first of the dismissals take effect. So they're minimum periods intended to ensure that the parties have a sufficient time to consult, and by specifying essentially a date by which consultation must have started. But as I've said, the overriding obligation in the legislation is that consultation begins in good time before the redundancies take effect. So what does that mean? Well, the tribunals have accepted that in good time means no more or less than time sufficient for fair consultation to take place, working back from the final date, which is the first date of the dismissal. So that kind of involves looking at many factors. So the number of staff involved, the number of unions involved, what's the reasonable amount of time for the unions and employee representatives to be able to respond to proposals and to make counter suggestions. But what you really need to ensure is that you begin the consultation process early enough to enable meaningful consultation to take place. So all in all, that kind of issue of the timing around the start of the consultation, it's a bit of a balancing act. And as the slide says, there's a risk of potentially starting too early in terms of the effect on staff morale and potentially risks around the leaking of commercially sensitive information. But if you start too late, that could have a detrimental impact on industrial relations, and it might, of course, run the risk of non-compliance with the statutory obligations that we're talking about today. So, of course, well, as you always would, you'd want to get it just right, but that might be something, getting it absolutely right might be a bit of a counsel of perfection, and as I said, it might be difficult to achieve in practice. It's just also worth mentioning around timing for those of you that have collective agreements or specific collective agreements around redundancies. You might just want to check those to see what, if anything, they say about the timing of consultation. Over to you, Sarah.
Thank you. So the HR1 form, this is the form that needs to be filed to notify the Secretary of State of large-scale, over 20 employees affected redundancies. As it says there, it's a criminal offence not to comply with that. It's a fine at level 5, which is the level at which fines are unlimited. So it is regarded as extremely important. It essentially gives the government a heads up of where there's likely to be large-scale redundancies in any particular geographical area. In terms of its provision, it also needs to be notified to the union or staff representatives, and I think it's probably pretty commonplace to provide it at the same time as you provide the Section 188 information, just simply because it's quite often at that stage that, you know what, you've got the information there, it's something you can get it out of the way. But in terms of actual time limits, you'll see that it needs to be filed at least for 45 days before when the first dismissal takes effect, and 30 days if under the 100 redundancies. So whilst commonly supplied with the Section 188 information, it's not absolutely critical to do that. You just need to watch your timing again. There's a question being put on the Q&A about whether or not you have to update your HR1. Yes, you do. If you're proposing additional redundancies, you may well find you have to file a second HR1. But in any event, the form has some wording on it that says if any of the information here changes, you must update immediately. So they do expect to receive updates on any changes that occur in the process. Is it still me? Yes, it is. So taking control. This is all about preparation for me. It's prep when you know this is coming. Obviously, sometimes you don't know it's coming, but quite often you do. And what you don't want to do is leap into this process without having worked up a proper project management plan. My advice to everybody is always to work backwards. So, you know, look into the future, look at when you need the changes or the dismissals to be taking effect, and work back from there. So you work back, factoring in the notice periods, factoring in the period of individual consultation that ideally would always follow collective consultation. The collective consultation period, the period for electing reps if you need to elect reps, the period for training reps if you're going to do that, and I think it's probably increasingly good practice to do so. The period for putting out the initial announcements. So actually, when you look at this, although the minimum periods for collective consultation are stated to be 30, 45 days, actually your project plan is going to extend over a much longer period. And within that period, you're going to have to build in some flex. These things don't always go entirely to plan. And as we've said, good time doesn't necessarily mean those minimum periods anyway. So you build in a bit of flex. In terms of where you've got notification requirements like the HR1, you obviously have that in your project plan. And you want to go into this knowing that you're going to have probably some challenge on your proposals. So you need to know what your A, B, C plans are. Where is the flex there in your proposals? Think in advance about the questions that are going to be asked. So mid-process, you're not having to scrabble around to deal with the queries that are coming. In a lot of cases, you should be able to foresee where employee reps or the unions are going to attack you on those proposals. So again, think in advance. Pre-prepared is great, because then you're still going to come away from consultation meetings and have to think about how you respond, but you're not going to be scrabbling around in the same way and having to potentially delay meetings and delay your own process whilst you put together a response on these things. And be realistic. If all you factor in is the 30 or 45 days for this process, you will really struggle. And what's really key about these processes is being prepared to be transparent with the staff and the reps. You need to be ready to build trust. It's a difficult time for the reps and the employees, and they're not going to like the messages probably. But if they feel that they are being dealt with in a straightforward way and they're being told facts, then that's far better. Again, we've seen processes where employers have tried not to engage on certain points because they're difficult points to engage in, but what that's ended up doing is just losing control of the process, because then you're in a room with antagonistic reps. So it's best to be prepared to be pretty transparent about what you're proposing and why.
Thanks, Sarah. Finally, what about the issuing of notices of dismissal to employees? This is a kind of matter that quite often causes confusion, and it's really looking at the relationship between the employer's duty to collectively consult and then also the employer's duty to give kind of proper contractual notice to employees to terminate their contracts of employment, in accordance with the contractual entitlements. So what are the key issues that you need to be aware of in this respect? Well, one thing that's absolutely clear is the first point that I've made on the slide there, which is that employers can't serve notice of dismissal on an employee until the consultation's been concluded. And if they do so, the employer is obviously going to be at serious risk of a protective award being made. But does that mean that an employer can't serve notice of dismissal in any circumstances until 30 days or 45 days, as applicable, has passed? And the answer to that question's no. So that this requirement for the minimum period of 30 days or 45 days to have elapsed is between the start of the consultation and the date that the first dismissal takes effect. It doesn't mean that the duration of the consultation itself has to be for 30 days or 45 days. And it leaves open this possibility that, provided meaningful consultations taking place, notices of dismissal could be issued during the 30-day or the 45-day period, so long as the dismissals themselves don't take effect and occur no earlier than the end of the statutory consultation period. Obviously, you would need to take into account individual consultation as well. So, just for example, if an employer is undertaking a 45-day consultation, that employer could potentially issue notices of dismissal after, say, 30 days, so long as the dismissals don't take effect within the 45-day period. But if an employer is taking that approach, it's going to want to be confident that it can demonstrate that meaningful consultation has taken place in order to reach an agreement or to exhaust the possibility of an agreement being reached before the notices of dismissal are issued. And so that then leads to the next question on the slide of whether the notices of dismissal should give actual notice of dismissal, 10, 5 weeks, etc., or should the notice of dismissal be a kind of payment in lieu of notice of dismissal, or could it be a mixture of the two? And really, that's a choice for the employer. So if you go back to my example of the employer undertaking a 45-day consultation, that employer, when it came to give notices of dismissal, Well, it could give the employees actual notice in accordance with their contracts of employment, provided that the dismissal itself doesn't take effect within the minimum statutory period. But if it gave actual notice, say 3 months, that might mean that some employees would remain in employment after the end of the statutory notice period until their actual notice period expired. Or the employer could give, say, the employees 15 days actual notice in respect to the period prior to the statutory minimum notice period, and then pay any balance of notice as a payment in lieu, so that the employee's dismissal took effect at the end of the statutory minimum period. Or that employer could just wait until the end of the statutory period and then give the employees who are going to be dismissed actual notice or a payment in lieu of notice. So there is a kind of possibility of mixing things up. But the key point is that notice can't take, or that the dismissal can't take effect within the statutory minimum period. And then the final point that I put on the slide there is that requirement under Section 165 of the Employment Rights Act for an employer, when making a redundancy payment, to give the employee a written statement indicating how the amount of the redundancy payment has been calculated. So you just need to make sure that you comply with that. So I think now we're going to turn to questions.
Yeah, so one of the questions that's been raised is our views on having a redundancy policy or an organisational change policy. They're not necessarily the same, obviously. My general view about redundancy policy is that they tend to be more of a hindrance than a help, because although what we're talking about here is massively complex, there is also huge flexibility in how an employer can run any particular redundancy process. And a policy is likely only to fetter how you can proceed in any particular situation in a way that you just don't need to have there. So beyond going past a sort of a one-pager that has some commitment from the organisation to, comply with statutory requirements and I don't know, provide support services for employees, which, think about to what extent that is desperately useful for you. I'm not a big fan of them. They tend to, as I say, take away some options from employers that might otherwise have existed in any particular circumstance. So yeah, not a huge fan. I don't know if Stuart, you've got an alternative view, but I don't really like them.
I mean, on that point of org change policies, I mean, certainly within public sector organisations, there's obviously quite a lot of pressure or to have those types of policies in place in terms of staff side arrangements. I suppose the key point there is not really fettering your options and giving yourself kind of flexibility in their operation. Got a few questions actually around fixed term contracts. So a question here, fixed term contracts, do people on fixed term contracts not go through redundancy at all? Question mark. What if they've been on a fixed term contract for over 2 years? Are they then included as other permanent employees? So the point there, I mean, that arises out of my kind of discussion around what's dismissal for the collective redundancy purposes. So the point there is that if you're dealing with a 90-day period and a fixed term contract expires within that 90-day period and the employee's employment terminates, that isn't counted towards the kind of 20 or more total, because the termination's taking effect as a result of the expiry of the fixed term. But that doesn't mean that for all purposes you don't need to treat the employees fairly, particularly if they've got more than 2 years. So if you've got an employee with more than 2 years on a fixed term contract and the contract isn't going to be renewed on its expiry, that's a dismissal for the purposes of employment law, and you're going to have to identify what your fair reason is and follow a fair process having regard to that fair reason, and if the fair reason's redundancy, and you're dealing with this person with over 2 years employment, then you're going to have to individually consult with them.
Thanks, Stuart. So we have a question about volunteers, whether they would normally come from the affected group of employees, or could it apply to a wider group? I think so again, this is an area where the employer has quite a lot of discretion, and I suppose it depends on why you're making your proposals. If your proposal is that if you're just trying to take cost out of the business, as opposed to having to reduce a certain specific number of employees because that particular need has fallen away, then you might ask for, throw open a volunteer process open to a much wider group, see where you get your savings, and then see how that changes what a mandatory process would look like. On the other hand, if you know you need to take staff out in a certain area, opening up a volunteer process to the wider group is not going to assist you at all. And then on the question about whether consultation has to always be in writing, it's absolutely not all in writing. Just that the Section 188 information has to be provided to the reps in writing, but there is a real expectation here that there's going to be face-to-face meetings, people in a room debating the topics, whether that's in a room physically or online. Partly that can happen, but it's certainly not a paper trail at all. It is live meetings.
And there's a question here. Our staff are on 3 months' notice. At what point do we start the 45-day consultation? Well, I mean, as Sarah was talking about there in her taking control section, I think you need to factor in notice periods when you're looking at the kind of entire timetable of the exercise. But in terms of starting the 45-day consultation, you really need to look at what the statutory obligations are. So that's to start the statutory obligation, consultation, in good time, based having regard to what I said earlier. And if you manage to complete the statutory consultation, say, I don't know, 30 days in to the 45-day consultation period, so that those staff are then going to be entitled to 3 months' notice of dismissal. As I said, the dismissals can't take effect within the 45-day period. So the choice then is give them actual notice to take them up to the end of the statutory minimum period and pay them in lieu, or give them 3 months' notice, which will then extend them beyond the statutory minimum period. But that's going to be no work for them to do, and so one kind of way of proceeding there is to pay the employees in lieu of notice, and that will potentially help them have time to find alternative employment.
Thanks, Stuart. So I think we've probably got time for us just to deal with a couple more questions. In terms of, there's a question now about, is the protective award limited by the week's pay limit in RPA? No, it is not. It is gross pay, and there's no limit. So essentially, you're talking about a quarter of your payroll for the affected employees that you're putting at risk. And linked with that, the question about what do you do if we don't have time to elect reps and we're on a tight time frame? Well, that absolutely comes back to, again, what I was saying. You need to find time or factor in the 90 days pay potential. Being on a tight time frame, unless you're able to argue that you've made your way somehow into the special circumstances defence, and as I say, that's not easy to do, and you would even then have to show you've done what you could to comply. The fact that you're on a tight time frame is not a defence. So you'd have to decide whether that really is at the time frame you've got to work to, and can you afford the risk of that 90 days pay. Stuart, I don't know if you want to take a final question.
there's a question that's just come in. Do you have to pay holiday entitlement for the notice periods? Well, if the employee's employment continues, you give actual notice. You would. If you pay in lieu of notice, you probably wouldn't, but you'd need to just check the provisions of the contract of employment. Okay, I think we're at the end of the time for this morning's webinar. Thank you again for attending. We really appreciate it. Do please give us your feedback when the webinar ends, and hopefully you've got it connected with Sara or I. So if you do have any questions, please feel free to contact us. Thanks again for attending, and hope to see you on another People Matter webinar in the future. Thanks a lot.